What's up, everybody? Welcome in. We have a really fun episode today on something that is near and dear to my heart that I do very often in my cases. I understand it better than most legal documents we talk about on this channel, as it is something I have used as a tool in almost every case. And it is something that we have litigated and been successful in using as a tool for many, many years. We've actually taught some lectures on it, talked about this at some seminars, and that is proposals for settlement. On today's video, we're going to talk about whether or not it's actually secret, what that means, and the fact that Steve Bertolino says this happens in every civil litigation. According to WFLA, I assume he said that to JB. I believe he and JB do text once in a while about this case. So we'll talk about whether or not that's true, and this is something that actually happens in every case, or is it more significant? And if it is significant, what is the significance of a proposal for settlement? It is a mechanism that is supposed to further settlement and creates leverage for the side that files it. So we'll talk about all that and more on today's episode. Hit that like button if you enjoy this video and if you enjoy this content and if you enjoy talking about this case specifically. Enjoy maybe is not the right word, but if you are interested in this case specifically and seeing what happens in a very different and unusual case in the state of Florida, when we talk about the infliction of emotional distress based on somebody that did not actually commit the crime, and maybe not even based on what they said, but what they didn't say or what their lawyer said on their behalf, because that's what this case is about. But specifically today, we are going to focus on the proposal for settlement. Now, why is it called a secret proposal? Why is the proposal, quote unquote, confidential? Well, I'm going to share my screen so we can see what was actually filed and talk about it a little bit. So this is what the document looks like that you file when you do a proposal for settlement in Florida. It is titled Defendant Stephen Bertolino's Notice of Serving the Proposal for Settlement to Plaintiff Joseph Petito. So just on the title alone, there are some things we can learn. In Florida, the rules say your proposal for settlement should be specific from defendant to plaintiff. So in this case, each defendant will file and should file, and I believe they did when I looked at the docket. Each defendant individually files a proposal for settlement to each plaintiff. So there's also one defendant, Steve Bertolino, serving a proposal for settlement to plaintiff Nicole Schmidt, because she is also a separate plaintiff in this case. So when we're talking about a proposal for settlement, what is the amount, right? That's what everybody wants to know. How much money did they offer? Is that what's a secret? Well, the answer is yes. Most settlement discussions in Florida, I'll specifically stick to Florida, are confidential. And they cannot be used in open court, used at trial to say, oh, this person offered me $5,000. So obviously they're admitting that they're wrong. Most settlement offers are confidential, and a proposal for settlement is no different when it comes to the amount or whatever they're offering. Okay, that's number one. So what is this filing? Well, in Florida, you file the notice of serving a proposal for settlement. You don't actually file the proposal for settlement. That is a different document, and I'm going to show you that a little later in the video of what the actual elements are in a proposal for settlement in Florida, for example, and what you ask for. So the notice is what is actually filed, and that's what's public record. But the proposal for settlement itself is just emailed or mailed to the lawyer and the party specifically that it's dealing with. So whatever the proposal for settlement was for Joseph Petito from Stephen Bertolino specifically was sent to Stephen Bertolino's lawyer. Sorry, Joseph Petito's lawyer, which is Patrick Riley, and you can see that in the certificate of service that I hereby certify on September 1st, 2023, the foregoing was electronically filed with the court, which will give electronic notice to Patrick Riley and other people. But the actual proposal for settlement with the amount and what specifically you're looking for and what you're looking for in return of that, or in return for that, was sent to Pat Riley. So let's read the paragraph now, what actually comes on the notice. Comes now, this defendant, Stephen Bertolino, by and through his undersigned counsel, and hereby gives notice of serving a proposal for settlement upon plaintiff Joseph Petito in accordance with Florida Rule of Civil Procedure 1.442 and Section 768.79 of the Florida Statutes 2023, dated this first day of September of 2023. So it lets everybody know, including the court, when this proposal for settlement was made and that they sent it. Now, they do have to perfect that by actually sending what the proposal is. So if they can prove, if Pat Riley can prove they never actually sent us a proposal, then this is all for naught. But if they do actually send the proposal, what does that do? Well, there are some timing requirements in proposal for settlement. You cannot file a proposal for settlement in Florida within 90 days of service of the complaint, meaning whenever, not necessarily when the complaint is filed, but when the defendants are actually served with that complaint, for those first 90 days, you cannot file a proposal for settlement. The court does that because they want each side to get an opportunity to learn a little bit about the case, do some discovery, do some depots, so you can properly evaluate the case. So what happens if they file this proposal for settlement and you don't feel like you've had an opportunity to properly evaluate the case? Well, you can file a motion with the court to extend time to respond to the proposal for settlement. Well, what is that time to respond to the proposal for settlement? You have 30 days to accept this proposal for settlement. So if you don't feel like with the 90 days plus the 30 days that you have enough information to answer or respond to this proposal for settlement or accept it, then that's when you would file the motion with the court to extend the time so that you can, oftentimes it happens where, they haven't had a chance to depose the plaintiff and they're like, Judge, we need to depose the plaintiff before we can actually respond to this. And sometimes the judge will extend time, but sometimes the judge won't. Because in our cases, sometimes we say, come on, let's do these depots. Let's set these depots. And the defense just doesn't set them and they're wasting time. Well, the court's not just going to extend it indefinitely because the defense is not doing their job, taking depositions and learning about the case. So it's important that everybody's doing their job appropriately in order for them to have an opportunity to learn the facts of the case so that they can determine whether or not they would like to accept this proposal for settlement or not. Because there are some major ramifications if you deny a proposal for settlement or do not answer it within the 90 days. If you do not answer it within the 90 days, it is within the 30 days, it is deemed rejected. And that's important because this is a huge mechanism in civil litigation. And I'll just answer the Steve Bertolino quote that this is something that happens in every civil litigation. That is categorically wrong. Virtually every, maybe. Most, I would say yes. Most plaintiffs really should use this, and some defendants should really use it, because if you feel like you're properly evaluating the claim, you should file a PFS and start that mechanism because it can have an effect later on in the case, but it doesn't necessarily happen in every civil litigation. But I would say most. So I'm not going to quibble with that too much when he says this happens in every civil litigation. So what does it do and why is it important? Before we answer that question, I'm going to bring up a blank example of our proposal for settlement. So here we go. This is kind of a sample that we use for a proposal for settlement in Florida. Plaintiff's proposal for settlement to defendant blank only. So we do each plaintiff and each defendant always. And again, this looks like a pleading. It looks like something you would file. It looks like that notice that we were just looking at, but it's not. This is not something that's actually filed. This is just something that is sent to the other side when you make this offer, when you make this proposal. Comes now the plaintiff by and through, undersigned counsel. According to these rules, same rules reference of what we already saw. The name, so we name the party or parties, and we put this in here because this is what we take from the rule to make sure we're getting it right. Name the party or parties making the proposal and the party or parties to whom the proposal is being made. So we say the plaintiff, and we put the plaintiff's name, makes this proposal for settlement to the defendant, and we put the defendant's name only. Now, there's been litigation in the past that you can do multiple parties. We never do. Just to make sure it's very clear who is making the proposal to who. We think that's best practice to only do it one plaintiff to one defendant. Number two, identify the claim or claims the proposal is attempting to resolve. So what are you trying to resolve with this proposal for settlement? This is important. We've looked at cases before where there are many different claims, Maybe you want to make an offer on count 1, but not count 2. Or maybe you want to make an offer that resolves all claims. Now, most commonly in our cases, it's all claims raised by plaintiff in the complaint. So it's not any other claims. Maybe there is some other claim the plaintiff could have or might have in the future. But guess what? The only claims we're talking about settling in this case are the claims raised in the complaint. And if it's just specific count numbers, we'll put the count numbers in there. So the other side knows with absolute specificity which plaintiff, which defendant, which claims we're looking to resolve. And it's a bargain for exchange, right? So we will dismiss all of these claims if you do X, Y, and Z. State with particularity the relevant conditions. You can put extra conditions if you have. As Florida's been updating, non-monetary conditions can sometimes invalidate a proposal for settlement. We don't need to get into that. But for the most part, this is what people want to know. What are you asking for? State the total amount of the proposal and state with particularity all non-monetary terms of the proposal. Now, as the rules change, non-monetary terms are something that is being removed, really. At least that's where we think it's going in Florida. And it has already gone there in certain circumstances. But this is where you put the amount of money to be paid. $50,000 to be paid within 10 days of the date of the acceptance of the proposal for settlement by defendant. Only this defendant and only this plaintiff. Now, again, a lot of this stuff is still going to be argued. A lot of these rules are changing and new in Florida, but the paid within 10 days of the acceptance technically could be argued as a non-monetary term. Same thing with, that you have to sign this release if a defendant makes an offer. Sometimes people will say that's a non-monetary term, so you can't add that into a proposal for settlement. That will invalidate it. Those are things that are being litigated, and we don't necessarily have all the answers. People have their opinions. Some people want to be safe. Some people want to put extra terms in. But this is what his proposal for settlement that he sent to Pat Riley would look like, all of these defendants. They would state the amount of money, and if they have any non-monetary terms, maybe Pat Riley would argue that makes it an invalid proposal for settlement. Maybe not. State with particularity the amount proposed to settle a claim for punitive damages, if any. So any claim or count that has punitive damages, you separate and specify that in a separate paragraph. Usually, you don't have to, but to make it clean, that's how we do it. And then state whether the proposed includes attorney's fees and whether attorney's fees are part of the legal claim. Each party will bear their own respective attorney's fees and costs. The vast majority of our cases, that's the information we put in there. But if there is a claim for attorney's fees, you specify that as well and set that out as well separately. So that is the information that should be put in a proposal for settlement by all of these defendants and sent to Pat Riley for each of the plaintiffs in this case. Okay. So why file a proposal for settlement? Why is it so important? Why is it something that I do in almost all of my cases? Our whole firm, I should say. Why is it something we do in so many cases? Well, if you reject a proposal for settlement, or if you let it lapse and you let the time period go by, if you go to trial and you beat your proposal for settlement by 25%, you can be awarded all of the attorney's fees and costs above and beyond the proposal for settlement, the verdict, whatever it may be, the settlement in your case. So let me explain to you what that means. Let's say, and we'll use easy round numbers. If you're the plaintiff, right? Because it's different if you're the plaintiff defendant. I'll give you both scenarios just so you can understand. If you are the plaintiff and you file a proposal for settlement for $100,000 and your verdict is anything more than $125,000, you now get to tack all of your attorney's fees and costs on from the point of the proposal for settlement on. So you don't get anything before that. You don't get the first 90 days. You don't get anything that happened pre-suit. You don't get to tack that on. But let's just say day 91 after service of the complaint, you file your $100,000 PFS. Then you litigate the case for 2 years. You spend $100,000 on experts. You've got $300,000 in attorney's fees. And you go to trial and you blow it out, you get $1 million verdict when you were willing to settle for $100,000, day 90. Well, guess what? That $1 million verdict, you get that, but you also get the $300,000 in attorney's fees plus the $100,000 in costs tacked on top of that $1 million. So that 1 million becomes 1.4. Or let's just say you get 126,000, you beat it by 25%. And so that's only 126,000 bucks. So you barely beat the 100, but guess what? You get to tack on $300,000 of attorney's fees and $100,000 of costs. So now it's $526,000 instead of $126,000. As the plaintiff, let's take it to the flip side for the defendant. Day 90, you file your proposal for settlement for $100,000. Well, beating that as the defendant would be 25% less than your offer. So you go to trial and you get the verdict, the plaintiff actually wins, but they get $74,000. So they did not hit that threshold of breaking 75. So what does that mean? Let's say you have the same expert costs and the same attorney's fees on the defense side. Well, you say, okay, here, Mr. Plaintiff, here's a check for $75,000. Now you owe us $400,000. So the plaintiff ends up negative $325,000 because they did not take the proposal for settlement when they had the chance. It is a huge leverage tool. When I tell you, once we file it and it expires, it is a topic of conversation every time we talk settlement for the life of the case. So why? Why is it like this? Why does it seem like a game? Why does it seem like a trick? Well, it's not. It's actually incredibly fair and balances the playing field. Both sides should think this is fine. And let me explain it to you. And I think you'll agree with me, especially those of you that are, logical thinking and not, even if you're emotional, I feel like you can understand, everybody's got logic and emotion, but some people, lean one way or the other. But if I have a case and I'm telling you, listen, this case is worth more than $100,000, but my client doesn't want to do this for 5 years. So they'll take $100,000 right now, even though their injuries are worth $1 million. Usually, we don't say that. Usually it's like the case is worth 120, but they're willing to take 100 now to be done with it. So we file that PFS for $100,000. And the defense says, you know what? Kick rocks. We're not paying you $1. Or we'll pay you $10,000. We're not even going to pay your medical bills. Or we'll pay you $50,000, but we're not paying $100,000. It's like, okay. So what did the defense just do? They now have forced you to litigate the case and live through this as the client for 2, 3, 4, 5 years, however long it takes. Many times after we litigate it for 2 or 3 years, the defense comes and says, and I'm sure this goes both ways. I'm just giving you my experience as a plaintiff's lawyer. The defense comes and says, please, will you take the $100,000? Take the $100,000. Fine. You were right. It's worth $100,000. And we're like, we've spent $100,000 on experts now. We didn't have to hire any experts before. We knew that this was going to happen. We've had to work this case for 2 years. We've had to pay staff. We've had to pay attorneys to work this case. It's impossible to settle for $100,000 now. You knew that. You knew we didn't have the costs and the time in it at the time and had the opportunity to settle it. Now we can't. And we go to trial and we get more than what we told them it was worth back then. We have to, not call our bluff. We got to put our money where our mouth is. We got to prove we were right in court. And when a jury says we are right, you have to pay for that now, for the delayed justice, for the misery you put our client through. And we all knew this case was worth it back then. Same way the other side. If you say this is a bogus claim, but you know what? We'll give you $100,000 to go away. And they say, no, we want $1 million. As a defense, you can say, you ain't getting $1 million. I don't think you're ever getting $100,000. And that's the bet the defense makes when they offer $100,000 and they go to trial and they win. 0 verdict. Or they lose because they admit they caused the accident, but you only had $10,000 in bills. So the verdict's $10,000. Guess what? They beat their PFS and you get your $10,000, but you have to pay them back all the money that they had to spend defending a claim that you asked for an outrageous amount of money on, or a fraudulent claim if they believe the claim is absolutely fraudulent. But they're still willing to offer $10,000 because they know they're going to have to pay their lawyers hundreds of thousands of dollars, and you don't take it and they go prove it was a fraudulent claim and the jury comes back and 0, like the Gwyneth Paltrow, Terry Sanderson situation, not fraud, sorry, but a 0 verdict. So she had the opportunity potentially to collect attorney's fees and costs. That's a leverage tool and bargaining chip that ended up getting Terry Sanderson to waive his appellate rights. And that's probably because of PFS. I don't know that that's what happened in that case. A proposal for settlement is what we call a PFS. But that's how you create leverage with this PFS. And it is very fair, regardless of what side you're on. If the other side is treating you so unfairly and not appropriately valuing your case, you can put your bet down. And if you're right and they're wrong, they have to pay for it. So it makes them look at the case extra hard from both sides. So does this mean the offer was significant? No. I have seen many proposals for settlement for $1, for $500, for $5,000. And that usually indicates that the other side thinks you have no case, or they think you're committing fraud, or they think they're going to win a motion for summary judgment, which that's another ticket. If the defense files a proposal for settlement for $500 and you say, no way, my case is worth $1 million, but you just can't prove it past summary judgment, and the judge summary judgments your case out, dismisses your lawsuit, well, now you've lost, and that counts as a zero. And a zero is 25% less than $500 or even $1. And so now you owe them all the attorney's fees and costs from the proposal for settlement to when your case was summary judgmented out. So it is a significant legal tool in the process, and why you have to appropriately evaluate your cases as lawyers. And you as clients have to trust your lawyer when they tell you, listen, you should think about this. Because if you lose, you could be looking at a lot of money that you have to pay the other side. Even if we win, but don't win big enough, they could be looking at you for their attorney's fees and costs. So it doesn't mean that it's a significant amount of money just because they made a settlement. Almost all settlements are secret or confidential. And I'll just talk Florida. This is a Florida case. So there's nothing shady about that. But I will say, it is something, regardless of how small this offer is, it's something that Petitos have to seriously consider. Are they evaluating their case appropriately? This starts a lot of conversations with clients. You have to explain to them all of the risks that are involved when a proposal for settlement is filed. You explain to them the reasons you file a proposal for settlement, and usually you don't file one for $5 million pie in the sky. Usually if they offer $1, you try to do a PFS for, the bottom kind of what you think the case is worth. And just because you file a proposal for settlement, these are a lot of questions you guys probably are going to have. Just because you file a proposal for settlement for $100,000, that doesn't mean you don't go to mediation 6 months later and you can say, no, we want $250,000. You should have taken that PFS. It's gone. So the number can still go up. Again, costs go up. The value can go up. You can find out your client has more injuries or more problems or needs more medical care in the future. That stuff happens. And just because you file a PFS doesn't mean you have to start there at any future negotiation. And frankly, most of the time we don't. So it's always an interesting process. We always advise it, because if there's an opportunity to settle a case sooner than later, usually that's better for the client, because it's not fun to go through a lawsuit. And this is a very interesting legal tool. And people had questions about it today. I saw JB talking about it, which is cool. If you guys have any more questions, let me know in the comments. Let me know what you thought about this video. Breaking down kind of a process, getting into the weeds a little bit more, explaining why it can be significant. It was fun for me because I enjoy this type of litigation and the negotiating leverage that you get with tools like this. Excuse me. So that's all we've got today. Thanks for joining me. Hit that like button on your way out. I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast, featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.